What did you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes,
bank
it
in any way whatsoever.
Hold on, let me finish.
No, I'm not gonna let you finish that
Okay.
particular statement.
I said, I want to
Because
practice
I
this.
just
Don't
need-
want to argue.
I need you to,
I just want you to
redirect-
understand.
Put you down, you know, you're 19. Do something with your life. Don't become a statistic.
note a couple things for the record. Ms. Butler, I received a pro se filing from you yesterday. There were some documents and things mailed to the court. Do you recall doing that? You recall sending this to the court?
I sent it to the young lady, yes.
Okay, so I am going to scan this, put it up into your file,
Okay.
but I just want to note for the record that
Yes.
we don't permit what's called hybrid representation, okay? So you have counsel, you can't also submit matters on your own behalf. Anything you want to submit to the court, you have to submit through your attorney. Do you understand that?
Yes,
You do understand that?
yes.
Okay, and then the matters that you submitted aren't matters that we understand in this court. You submitted what we refer to as pseudo-legal jargon, or matters that are contractual in nature and have nothing at all to do with a criminal court case. So I'll upload them into the case, but I'm also going to strike them from the record, okay? Just so you're aware.
Mail that to the clerk. I didn't mail it to, that's private that you have, the documents that you have.
Do you have another case pending somewhere in the court system, other than this one?
This is just this case here.
Okay.
Those was private documents. It wasn't for public only. Let me say something. Because I'm not being represented, and I'm not, my evidence is not being presented like it's supposed to be. Yeah, because you're not helping me. Would I be able to say something? Okay.
All set, trial by jury on August 18th and 19th. So Ms. Butler, I set you over for a jury trial on August 18th and 19th, 2026. If you fail to appear for your jury trial, I'll hold it in your absence, and you can be convicted even if you're not present. You understand that?
I comprehend.
We're adjourned.
Your Honor, before we adjourn,
Can you grab the mic?
before we adjourn, Your Honor, I know Ms. Butler wanted to make a statement if court would allow that.
Okay, go ahead.
How you doing? The reason why I might have to let Mr. Pribble go because I'm not being helped with my case. There's a lot of violations that happen towards me. There's a lot of my evidence has been tainted, and it's a one-sided case. There's a lot of due process violations that occur, and no one want to listen. Everybody's being selective-minded, and I just want to address that to the court. I have so much evidence that I have presented in this court to show you, to prove to you, show facts, and also show you there's a lot of concealment within this court.
You want to represent yourself at trial, you have a right to do that, just as you have a right to have counsel present and have a court-appointed counsel if you can't afford one. But before I make that decision final, I want to make sure you understand what you'll be giving up. You understand you may have a number of defenses which apply to your case, which an attorney is trained to know. Do you understand that?
I comprehend.
Okay. And do you realize that if you were convicted of the offense in this case, that you're facing a possible penalty, 2 level 6 felonies. So each one of those would carry between 6 months to 2.5 years in prison. So the total combined penalty could be 1 year to 5 years in prison. Do you understand that that's the possible penalty?
I comprehend that as well.
You realize there are factors the court can consider in increasing your sentence within that range or in decreasing your sentence within that range, and that those are called mitigating and aggravating circumstances, and that a trained attorney knows how to identify those and present those to the court?
I comprehend that.
Okay. Attorneys have developed certain skills, and an attorney can also evaluate the strengths or weaknesses of the case against you and give you expert advice on whether you should attempt to seek a plea agreement with the state, which which may result in the dismissal of some of the charges and a recommendation for a favorable sentence in return for your plea of guilty. Do you understand all that?
I comprehend it.
Okay. You must understand if you decide not to have an attorney, you will not receive any special treatment with your defense. You have to follow the same rules and procedures in your case as an attorney would have to do. Do you understand that?
Yes, I comprehend that, so.
Okay, so you filed these documents with the court, and these documents make statements about an Office of Executor Observations, findings regarding Porter County Superior Court interaction with Tierra Lene Butler. You talk about final order to settle and close.
Yes.
Different things like this.
Yes.
And then there's like a recitation of chronology, different things of that nature. And a few minutes ago, you mentioned something about how the clerk's office is helping you like settle your accounts and different things of that nature. You understand that those aren't themes or processes that are part of the criminal court proceeding?
Well, I had did some research on my case, and I noticed that my ad in a high.
That's not the question I asked.
No.
I think you misunderstood the question.
It's not criminal. It's not criminal.
Oh, you're here in a criminal proceeding. Do you understand that?
Yes, I am in a criminal proceeding, but like I've been trying to explain ever since when I had.
Well, I need you to answer the question I asked you.
Okay.
Which was whether you understand that these documents and things that you file with the clerk's office, what's the receipt date on this?
It should be April 16 or 15.
April 16th it was received, so just yesterday. That these aren't criminal matters that you filed with the court?
Those aren't criminal matters, the violations that have been held against me. Yes, that's a lot of violations.
You understand they're not, though? I mean, these aren't things of a criminal nature that would be part of this criminal case.
Well, you saying what I just filed is not what criminal?
This
Explain a little bit
document,
clearer.
these papers seem to indicate that you're trying to proceed in equity or under
Yeah,
sort of a pseudo-legal jargon, some type of a,
Is we in the Article Court 3 right now?
say again?
Are we in the Article Court 3 right now?
I don't understand what you mean. This is
Means
the
that-
Court of Porter County.
Okay, so we basically still in the same court as administrator. So you're basically trying to administrate Mr. Bank. I understand how the.
What'd you say?
This court system operates like a bank.
Okay, it doesn't, ma'am. This
It
court system
operates.
doesn't operate like a
Yes,
bank
it
in any way whatsoever. So,
Hold on, let me finish.
no, I'm not gonna let you finish that
Okay.
particular statement.
Like I said, I want to
You
purpose,
just
don't
need-
want to argue.
I need you to,
I just want you to
redirect-
understand me mentally.
I did the mental thing just fine.
Okay.
I'm not worried about any mental thing.
Okay,
What I'm worried
okay.
about is the conception you may have that this is some sort of court of equity or some sort of a business transaction, some sort of a bank, something of that nature, because it is none of those things. You realize that? This is,
They said, should a man prove himself to be living and not dead, nor loss of seed, his estate must be returned to him with mean profit. I am the living man that has a womb. I have accepted appointment of this office of executor. As such, this office gives notice of its observations and findings. And now I have issued orders, okay? And in the scripture, the living and the spiritual man judgeth over all things, yet he shall be judged by no man. And that's 1 Corinthians chapter 2, verse 15. Like I said, I came here with clean hands. And I'm now the executor. My estate has no longer been abandoned. And I don't allow no more trespassing and interloping upon and administrating it. I discovered a lot of things along the way, putting me in this position.
I think it's appropriate for me at this time now to terminate the Ferretta inquiry, deny your request to proceed pro se. I'll specifically find that the request is not a genuine attempt to present a legal defense, but a calculated strategy to obstruct and subvert the court's proceedings. The defendant's utilizing rhetoric of what would typically be called a sovereign citizen movement,
No.
including raising nonsensical
No.
challenges
No.
and attempting to apply commercial law to criminal prosecution
No.
or equitable law.
No, that's not
Ma'am, you
true.
keep saying no, but you're talking over me and I don't appreciate it because I'm trying to rule. The right of self-representation is not a license to abuse the dignity of the courtroom or nor relevant rules of procedure and substantive law. Based on the defendant's filings and her statements in open court, court finds she's unwilling to comply with rules of procedure and intends to use self-representation solely for deliberate disruption of the proceedings. The request to proceed pro se is denied and appointed counsel will remain on the case. We're adjourned.